Mrs. Lawyer Woermer, your client, Mr. Reiner Fuellmich, has been in pre-trial detention for 10 months due to allegations of embezzling donation funds amounting to €700,000. What happened to this 700,000? And where did they ultimately end up?
Ultimately, it was already apparent in the fall of 2020 that there were initial rumors about potential issues with government-critical organizations like MFGBD. There was a rumor from Professor Bhakti that accounts were being seized by the state and that money was being confiscated to obstruct and prevent government-critical work against the corona measures. Therefore, the money should be removed from the accounts. There were far more donations than anticipated, and they did not want to leave the money in bank accounts where it could easily be seized by the state. Instead, they wanted to secure it. Reiner told me that he had a valuable property and proposed that they give each other loan agreements. Vivian Fischer apparently also had some personal debts at that time, as indicated by a chat where she mentioned needing money for living expenses. Reiner Fuellmich wanted to use the funds to pay off a mortgage and to improve his house, making it more valuable for sale, etc. So they gave each other private loans, used the money privately, withdrew it from official trust accounts, and effectively channeled it through loan agreements to avoid state access. Reiner Fuellmich intended to repay the money from the sale of his property after the summer of 2022. Unfortunately, it turned out that lawyer Templin, with whom Reiner Fuellmich had previously worked on the class action project, had also provided Fuellmich with a loan, which had already been terminated by that time. However, Templin received approximately €1.15 million from the sale price of Reiner Fuellmich's property. And yes, there wasn't much left from the sale of the house to repay the loan to the Corona Committee. Und da ist nicht mehr viel übrig geblieben, das Darlehen aus diesem Verkauf an den Corona-Ausschuss zurückzuzahlen.
Why are the so-called Hafen lawyers, especially Marcel Templin, not being brought to court?
That's our question as well. In a ruling from June, the judge found that Marcel Templin had received at least €700,000 without legal justification, according to the criminal court. He did this using real estate mortgages. We've already had the notary involved at the time testify in court, and it was established that Templin received the money without any legal grounds. We also suspect criminal activity and filed a criminal complaint at the beginning of December. As of now, we are unsure whether the Goettingen prosecutor's office has taken any action. However, in our view, Marcel Templin should either have repaid the money to Reiner Fuellmich a long time ago or be standing trial himself.
Are you hoping for an acquittal?
Yes, of course, we are firmly hoping for an acquittal, which is the clear expectation of our client. As his defense counsel, we share this expectation unequivocally. Our position is that our client fully intended to repay the loan and was in a position to do so, as the funds were to be sourced from the sale of his property. However, complications have arisen due to internal disputes within the Corona Committee. Additionally, the complainant, Marcus Templin, wrongfully appropriated a substantial portion of the sale, proceeds from Reiner Fuellmich's property. This appropriation, which we argue was clearly without legal basis, has been corroborated by a ruling from the criminal court. As it stands, Mr. Templin has retained approximately €1.15 million from the sale, which remains in his accounts, and he has refused to return these funds voluntarily. We have formally demanded repayment from Mr. Templin once again, and we are in the process of initiating a lawsuit to recover the funds. One of our colleagues will be filing this legal action shortly. Given these circumstances, we firmly believe there is no basis for the breach of trust accusation, as the delay in repayment was due to the wrongful retention of the funds by Mr. Templin.
What do you hope to achieve with the international audience?
Well, it is of utmost importance to our client that we ensure public awareness particularly on an international level. We are increasingly concerned that the proceedings no longer fully align with the fundamental principles of the rule of law, specifically those that safeguard the principles of orality and public access in criminal proceedings. In mid-July, the presiding judge issued an order mandating that all motions, including evidentiary motions, procedural applications and other statements, be submitted exclusively in writing. These submissions are then reviewed by the criminal chamber in a self-reading process, and photocopies are distributed to the other parties involved. Subsequently, the substantive content of these motions is discussed in chambers, where the judges deliberate on whether to grant or deny them. The decisions are then briefly announced in open court, often following recesses that can last about an hour. After each decision, new motions are filed, and this repetitive process can continue throughout the entire day, with motions being submitted and rulings being handed down successively. Unfortunately, this method effectively leaves the public audience in the courtroom uninformed about the nature of the motions, the reasoning behind the decisions, and the overall progress of the case. This approach fundamentally fails to uphold the principles of public access and oral advocacy in criminal proceedings. Particularly in Germany, where the commitment to transparency in the judicial process was reaffirmed after the dark period from 1945, during which secret courts were explicitly denounced, this principle remains critically important. A breach of the principle of public access constitutes a serious ground for appeal. If public access is effectively excluded from a criminal trial, any resulting judgment is inherently questionable and may not be legally sustainable. If the judges have erred in this respect, as we believe has occurred in this case, this provides a strong basis for a successful appeal. We are confident that this issue will be a crucial factor in any potential appellate proceedings, given that the principle of public access has been egregiously violated, and the court's discretionary decision appears to have been flawed.